ನಿಷ್ಠೆಗಳ ಮಾಡುವರಾಗಿ, ಕಾಮಕ್ರೋಧವ ಅಳಿದವರಾಗಿ, ನೇಮ ನಿಷ್ಠೆಗಳ ಮಾಡುವರಾಗಿ, ರಾಮನಾಮವ ಜಪಿಸುವರಾಗಿ, ಪ್ರೇಮದಿ ಕುಣಿ ಕುಣಿದಾಡುವರಾಗಿ, ರಾಗಿ ತಂದಿರ್ಯಾ ಭಿಕ್ಷಕರಾಗಿ ತಂದಿರ್ಯಾ, ರಾಗಿ ತಂದಿರ್ಯಾ ಭಿಕ್ಷಕರಾಗಿ ತಂದಿರ್ಯಾ. ಹರಿಯನು ಅನುದಿನ ನೆನೆಯುವರಾಗಿ, ಗುರುತಿಗೆ ಬಾಹೋರಂಥವರಾಗಿ, ಹರಿಯನು ಅನುದಿನ ನೆನೆಯುವರಾಗಿ, ಗುರುತಿಗೆ ಬಾಹೋರಂಥವರಾಗಿ, ಕರೆ ಕರೆ ಭವವನ್ನು ನೀಗುವರಾಗಿ.
Sarvebhyo Namaha. A small announcement at the outset. From tomorrow we will have Shatabdhani Dr. R. Ganesh continue his lecture series on Telugu Sahitya Vihara. A warm welcome to all of you for those lectures as well. From the past 2 days we have had Kashyap Naik talk to us about religion and law in India, and all through these lectures he has brought a historical perspective to bear on the subject, and this has been very useful for us because, as all of us know, history is something that makes the same events of the world seem very steady and unvarying, whereas in actuality those events would have been precarious and unsteady. So Kashyap has granted this privilege of distance to look at the same events of the past in a very objective manner. We must thank Kashyap for it. And on the first day what he did was he spoke to us about how religion has been looked upon in our country, not just by the traditional Sanatana Dharma point of view, but also by Islamic rulers who had come to rule our country in the medieval period, and also by the British. And he made a very valid point on the first day that in the march towards Indian independence, there were many various memoranda submitted to the British by Indian political leaders, various patriots. But in none of these memoranda do we see that any reference being made to the religion of our country in order to protect the well-being of religion and various aspects connected to it. So it is obviously an lapse on the part of the political leaders and the overall political configuration of that day. So be that as it may, Kashyap's point, very valid point, which to our knowledge has not been noted elsewhere, goes on to prove that there have been various lacuna in the method of disposing history in our system, and it will do us all well to learn from the past and make amends for it. Yesterday Kashyap spoke about how our country was vivisected and Pakistan was carved out of India itself, and the various factors at play, starting from Muhammad Ali Jinnah and the Islamic tendencies that had come to govern Indian politics and so on. And he also spoke about the various articles in the Indian Constitution from 25 to 30 that concern religion in our country, how those terms can be interpreted, misinterpreted in various ways. So we thank Kashyap Naik for this instructive and engaging set of lectures. We all know how busy lawyers are, especially during the evenings. We thank Kashyap for taking time out of his busy schedule and addressing us on this important topic. As was evident, his preparation was thorough and the presentation was equally instructive and enchanting as well. So once again, on behalf of all our listeners and the Gokhale Institute of Public Affairs, we thank Kashyap Naik. I now request Shatabdhani Dr. R. Ganesh to present Kashyap with a small token of our respect.
Good evening, one and all. At the outset, I would like to apologize for starting the session 10 minutes late. I would also request you all to stay back 10 more minutes after 7:30 so that I could complete whatever I have already prepared to speak today. In the past 2 days, we have seen the historical manner in which law and religion had been treated in India, and several political factors which have also been clearly indicative of the manner in which the subject of religion has been taken into consideration by the Indian legal system up till the formation of the Constitution. And we also saw certain provisions of the Constitution. Now, before I even begin on several judicial precedents that have shaped the Indian jurisprudence on the subject of religion, it is necessary for us to see that with the advent of the Constitution of India, the remaining laws did not immediately differ. It is not that the framers of the Constitution or the members of the Parliament took it upon themselves to change every law that was framed by the British to make new law for us. The Constitution of India was the only legal document that was sat through, thought of and written. Several other provisions of law which were already in force in India were continued. Now, there are certain laws pertaining to the criminal law, which was the Indian Penal Code, which was in 1869. The Indian Evidence Act was of 1872. And the Civil Procedure Code was of 1908. So several of these legislations, I'm only quoting a few, there are much more. Most of these legislations were already brought in by the British, which were found to be sufficient enough to continue with the legal administration. It is not that the bureaucratical or the administration would change the moment the power wielding authority changes. The legislation would continue to be the same. The manner in which the courts were functioning continued to be the same. The manner in which the judges and lawyers were approaching the particular subject also continued to be the same. Earlier, the judgments on an appeal from all of the high courts would go to the federal court, and from federal court appeal would go to Privy Council. So some of the judgments of the Privy Council were binding on the federal court. After the Constitution of India was framed, the Privy Council was not the head of the Indian judiciary, it was the Supreme Court of India. Despite that, many of the Supreme Court judges on several points and legal issues, when they were following a particular judgment, they still relied on several Privy Council judgments, several judgments of the federal court as well, and they continued to deal. Several other laws pertaining to the not only the lands and several other aspects, but also matters concerning religion were also not immediately changed, they continued to be the same. And in matters of administration, we have always seen that religion is the last subject that comes to a framer's mind to think of, to legislate or change. Because religion, by its very nature, is a very, very private affair. At least in India, it's a very private affair. And it has to go to the effect of making a particular society and what changes it would have on the society. Only then politicians would think of making a certain law. But that was not so for the British. For British, they had to deal with every kind of situation, and they also had to deal with religion. And yesterday also, we saw several legislations that were framed. And I also quoted one of the legislation of 1927, in which that was for each prince estate, they had made the Religious and Charitable Endowments Act. And in that Muzra institution, I read out the definition. In that particular definition, we saw temples, chatras, the charitable institutions where free meals would be available, mosques, all the religious places were listed under Muzrai. But what was conspicuously missing in the word Muzrai was church. All other religious institutions would come under Muzrai, but not the church. So mosques, Hindu temples and several other community halls and so on and so forth were all under the definition of Muzrai. Then what happened? In 1926, there was a change in certain presidency towns. We see that in the last 20 years, there is a lot of effort by the British in order to give some sort of a veto, some sort of a benefit to Muslims so that they side with them. So as a result of this, what happens is, in the Religious Charitable Endowments Act, they make a new law in which it is called as Hindu Religious Charitable Endowments Act. And the word mosque is taken out of Muzrai. So all the laws that were applicable to the religious institution continued to apply for the Hindus and several Hindu temples, institutions, etc. But for mosques, it was taken off, and they framed a separate law called as the Waqf Act of 1923. Now, if you look at the Waqf Act and compare it with the size of any religious charitable endowments act of each state, it is probably less than 1/10. There are hardly about 7 or 8 sections in that, and they say a mutawalli would be appointed. How the the court would be there, which would be framed by the government, and the judge of the Waqf court generally is a person who also follows the same religion of Islam, and because several aspects of Quran and Hadith would have to be interpreted there, and therefore such a person is kept there. But how each of the Waqf would have to be administered is left to that particular mosque or the Waqf board. The way several properties were attached to a temple, several properties were attached to a mutt, similarly several properties were also attached to mosques. Now, in respect of these properties which were attached to mosques, they said you have complete leeway, the way you want you can administer, so on and so forth. But in respect to Hindu religious charitable endowments, there was specific laws on which each and every aspect had to be covered. We will look into this by way of judicial pronouncement. One of the major judicial pronouncements that came at the very first few years after gaining independence was the famous Shirur Mutt case. It was called as the charitable Commissioner of Charitable Endowments versus Lakshmindra Tirtha Swami of Shirur Mutt and others. The citation is AR 1954 SC 282. If there are any lawyers or persons who are interested to see this particular case, the citation might be helpful. Therefore, I am saying a few cases. Now, interestingly, what had happened in this particular case is the Swamiji of this mutt, Shirur Mutt, Lakshmindra Tirtha Swami of Shirur, he was appointed as the pontiff of the mutt when he was a minor in 1919. Then, after attaining majority in 1926, he took over of the management of the mutt. By then, several debts had also risen in the mutt. And the Swamiji between 1926 to 1930-31, he cleared off the entire debt. Then, as we all know that the Shirur Mutt is connected to the Udupi Sri Krishna Mutt, and we have the 8 mutts connected to it, and by Paryaya every mutt has 2 years of administration to the Krishna Mutt. So this particular Swamiji had the first Paryayam in 1931, he conducted efficiently. By the time the second Paryayam came, it was 1946. At that particular point of time, as you are all aware, there was World War II scenario, and there was a serious dearth for materials and for food and surplus, etc. Now, what was the condition in this Paryaya Mutt was that whichever mutt takes over the management of the Sri Krishna Mutt would have to ensure the entire administration from and out of its funds to the Sri Krishna Mutt. Free meals would have to be given. Anybody who comes there to Udupi Mutt and had to have had food, the mutt would give free of cost, and several other things would be there, and there would be a lot of expenditure. So here, when he was dealing with it, the expenditure within the 2 years and the number of followers coming there, having so many ceremonies, and the Paryaya, the ceremony itself is held in a very, very grand scale even to this day. All of this expenditure had mounted to more than 1 lakh. And this particular 1 lakh at that point of time, I am talking in 1946, was a very huge expenditure for a particular mutt to control. At that time, there was a lawyer in Udupi called as Lakshminarayan Rao. At his instance, a complaint was filed before the Commissioner of the Endowments in Madras. They were all covered under the Madras Charitable Endowments. And he said that this particular Swamiji is unable to maintain the affairs properly and the expenses is mounted for over 1 lakh. You please come and take over the administration. So they directed under section 61A of that particular act, and they said, you please appoint a manager to manage this particular institution. Now, as per the institution, as per the direction of the commissioner, the Swamiji appointed one person called as Sripat Achar and executed a power of attorney to him, and he said, you please continue. But within 2 years, from December 1948, the day he was appointed, within 2 years, it was found out that Sripat Achar was unable to, was not willing to do certain acts or particular functions which the Swamiji wanted. So the Swamiji said that as per my desire, nothing is happening here, and he was only supposed to administer it and in terms of finance and other things, but nothing that I want has happened. So in September 1950, he terminated the power of attorney. And after terminating the power of attorney, Swamiji filed a suit against that particular person. Sripat Achar went to the Madras Commissioner and filed one complaint before him saying that the revocation of the power of attorney was in violation of your order, So therefore it has to be taken off, and the termination of power of attorney is illegal. He filed a complaint there. He was represented there by the same Lakshminarayan Rao, who was the advocate who had put up the case. And what the commissioner did is, he did not worry about all this complaint, etc. He had powers under the act, so he drew up a scheme for management. Now what happens in any charitable trust, any public trust for that matter, if the trust is not functioning well, anybody can go and file a petition, even now in the court, and the court would draw up a scheme for administration, and as per that particular scheme, the trust would have to be run. So, but the board had the power under the legislation, that is the Hindu Religious Charitable Endowments Act, to come and control the entire affairs of the mutt. So the board took over and they said that we are going to control the mutt from now on. Challenging this action, the Swamiji filed a writ petition in the Madras High Court. Madras High Court granted a verdict in favor of the Swamiji. Then challenging that, the Commissioner of Endowment Commission, he preferred an appeal to the Supreme Court. Now broadly, what had happened was, by the entire time this dispute had happened, the old act of 1957 was repealed and a new act had come in place. But nevertheless, the actions taken under the old act was saved by the new statute. Then the several provisions of this particular law, the Madras Hindu Religious Charitable Endowments Act, was challenged as unconstitutional, because by then the constitution had come into force. So the Swamiji said that there are sort of fundamental rights of right to religion that has been granted to us. We saw some of the articles yesterday. So he said that has been violated. So therefore this act is violative of the provisions of the constitution and this must fail. Now what did the act say? I will just briefly say some of the provision and say as to what was the act doing. Section 18 of that particular act, the Hindu Religious Charitable Endowment Act, said that the commissioner and below him the DC and then the AC, they can examine all the records of any religious institution anywhere in the province of Madras, which included Mysore. Section 20 said that the commissioner would have general superintendence control over all religious institutions anywhere in this particular territory. Section 21 said that any Hindu officer drawing the power from the government could enter the premises and they could inspect at whatever particular time, and the mutt or the other religious institution would have to abide by any such orders. And 23 said it is obligation on part of the mutt or any other religious institution or temple to obey any order that is passed by the commissioner. They don't have a choice. Then section 24 said that how the administration should be conducted by the trust or by a particular mahant, whoever is there, or the pontiff. They said that a man of ordinary prudence in the manner in which he would run a particular institution, in that way he should function. But who would say whether he is functioning as a man of ordinary prudence or not? Commissioner would have a say on it. Then section 25 said that each of the temple and mutt should maintain a proper register, and this should be annually verified by the registrar again. And relating to the property and assets of the mutt, there were two draconian provisions. Section 29 said that none of the properties belonging to a religious institution could be sold at all. If the mutt or the trust or the temple wanted to do something with the property, at the max it could lease the property for not more than 5 years. And section 3031 said that how much ever is the expenditure that the mutt or the religious institution would want to incur in this particular year, they have to submit beforehand to the commissioner and say this is the overall expenditure. If in case a surplus is there in your hand than what the expenditure has already made in the books of account, that surplus would be handed over to the government. If in case the expenditure is lesser, you have shown lesser but the amount spent is more, the government will not give you that additional fund. You would have to say to the exact. Then section 76 said that how much ever income this particular mutt or temple or other institution gets, 5% of that net income should go to the government. This was the provisions of the act. So they challenged this particular act as unconstitutional, and they said it specifically violates my right to property, which was that time a fundamental right under Article 19(1)(f). They said it also violates my right to religion under Article 25, 26 and also 27. Now, after series of arguments, the court finally held that Article 19(1)(f), the term property used there, it does not only mean the property of land, assets, etc. It covers all the proprietary rights of the pontiff also. So therefore, it is not just immobile properties of the mutt, but all the proprietary assets of that particular mutt, including the various other this thing, is also covered under the term property. Then they came to Article 26. Yesterday I spoke about the word religious denomination. They said whether this particular mutt is a religious denomination. They said Madhvas are all connected to the Ashtamatas, and only the followers of Madhvacharya are called as Madhvas, and they are a very small sect. So therefore, and they have a distinctive name also, therefore they are a religious denomination, was also upheld by the court. Then they said, what is that particular protection that is covered under Article 25-26 vis-a-vis the state powers? State had power under Article 26 to frame a law which is secular in character, which is not religious but having any economical, social, financial or political aspect or on secular activity. The state could frame the law. So the state contended before the Supreme Court saying that matters of expenditure, how much is he spending, maintenance of register are all secular activities, because it is not only that the mutt or religious institution is doing, any kind of institution would have these finances, etc. So therefore they are all secular activities, and only religious activities on the way he is performing puja, that we don't care. But as far as this is concerned, the state generally has powers to deal with this. This is when the Supreme Court evolves a doctrine called as the essential religious practice. The Supreme Court in 1954 said whether this particular right that is asserted by the Swamiji here, that the maintenance and administration of the mutt is my right to religion or not, will have to be looked into from the standpoint of that particular religion to see whether it is so essential for the performance of your religion. Is it that if I take away your right, will you not be able to continue with that religion? So they said, if it is a very, very essential religious practice to you, then that particular right is handed over to you. If it is not an essential religious practice, then you cannot say. But the Supreme Court came up with a caveat saying, what is an essential religious practice for a particular religion would have to be looked into from the standpoint of that religion. You cannot say I am an atheist and I will look at what is the essential practice of a religion. So you should say from the standpoint of that religion, whether it is an essential religious practice. Then interestingly, the Supreme Court relies on a judgment of the US Supreme Court in this regard, called as Minersville School District Board of Education versus Gorbatis. Now what was that case? In that particular case, there were two school children who were going to the school called Minersville School, and there was a regulation in that particular district saying that whenever the US national flag is being hoisted every day in the school, all the students must salute and show respect to that particular national flag and then enter the classroom. These two girls, children of this Gorbatis, they would show respect but they would not salute, because they said we belong to a particular Christian sect called as Jehovah's Witness. We are called as a sect called Jehovah's Witnesses. So for us, there is no other God than our God, and we should not be showing respect to anybody other than our God. So we can't bow, we can't salute, we can't fold our hands before anybody other than our God. He is the only one who can command respect and nobody else. This is what the Jehovah's Witnesses strongly believe, and if that belief is taken off, then there is nothing more left in that particular religion. So to say that I should fold my hands and show my respect to teacher or to national flag or to national anthem is not possible. Then the matter went up to the court. The court said that no, you will have to show respect to national flag, and they rejected it. The matter finally went up to US Supreme Court. It is also necessary to see that it was the time when this concept of liberty, individual freedom, etc. had gone to its zenith under the US Supreme Court and US laws, and they were evolving these laws like nowhere else. And the Supreme Court took a very, very libertarian view, and they said the individual freedom is more important, and this particular person by virtue of his liberty strongly believes that as far as their customs under the Jehovah's Witness, they are not supposed to salute. But we have seen from the evidence that they were not disrespectful to national flag. They did not show any kind of disrespect, but they were not saluting. So that's okay. It is part of their liberty. I should accept it. And they ruled against that particular school. And there were also certain Australian court judgments on this very aspect of Jehovah's Witnesses. Our Supreme Court looks into the judgment of this US Supreme Court as well as the Australian Supreme Court, and they say that here what the Swamiji is saying, is it so essential to him the way it was so essential to this Jehovah's Witnesses for the performance of this particular religion? And they say that when it comes to matters of expenditure, maintenance of register, incomes of the mutt, etc., are all financial and other aspects, this will have to be considered as valid, and we cannot say that these provisions of the Act are unconstitutional. However, certain provisions of the Act which related to overall superintendence or other provisions of the act which said that the commissioner would come and take away a particular this thing. He would manage the entire affairs. He would appoint a particular authority to look into every day's business. All of these are ultra vires to the constitution and gave a certain relief. Now what happened to Shirurmat is a fact of that particular case. But the evolution of the legal principle was the essential religious practice principle, which has held the fort from 1954 all through until the recent judgment of Shabrimala, which is still being discussed by a larger bench. We'll come to that later. Then subsequently in 1954 again there was another case of Ratilal Gandhi versus State of Bombay, 1954 Supreme Court Reporter 1055. In this case, the petitioner before the court, Ratilal Gandhi, was a Vahivatdar of Vejalpur Jain Temple. There was a Jain temple in Vejalpur. So there he was the manager. Under the Bombay Trust Act, the charity commissioner, using the powers under the statute, had forced himself to be trustee of that particular temple board, and he was managing. So he said, I have powers, so for the purpose of management I can also become a trustee. So he said, commissioner wherever is there automatically becomes the trustee of this particular board, and we will continue. And this particular act of the trustee coming and the commissioner coming and sitting as a trustee was challenged, and the provisions of the Bombay Trust Act was also challenged before the Supreme Court. Then the Supreme Court, again looking into its own judgment in the Shirurmat case, held that all these financial aspects and secular aspects could always be regulated. So therefore those provisions of the Bombay Trust Act are all constitutional. But you cannot interfere into religious administration as per Article 26. So you cannot say how the Jain temple should be run in what affairs. That should be left to them. So they partly allowed the writ petition, and rest of all the acts of the Bombay Trust Act was all held to be constitutional. Then we see one more important judgment in 1958, Venkatramana Devaru versus State of Mysore, 1958 SCR 895. We have these three villages called Mannampadi, Bappanad and Karnad, which are jointly called as Mulki Pita in Karnataka itself. In this particular village of Mannampadi, there is a very ancient temple of Venkatramana, and the Gauda Saraswat Brahmins were managing this particular temple. So what they say is that we are all basically from Kashmir, and after the Islamic onslaught under Kashmir, we had moved to Bihar. We had stayed in Bihar for quite a while. From there again we had moved and settled in 60 villages of Goa. And after the Portuguese started persecuting us in Goa, we had no other option but to leave. Then we came finally and settled in South Canara and in several parts. And wherever we went, we took our own idols and we were worshipping. Finally, when we have come and we have stayed here, we installed and worshipped Venkatramana here in this particular temple. And this particular temple, which was run by a particular trust, in 1915 itself, they themselves had filed a particular suit for drawing up a scheme for management before the court. And this court had also decreed the suit in 1921, and they said this is how you are supposed to administer. Then what happened? In 1947, the Madras Temple Entry Authorization Act was enforced. Now, as soon as that particular act came into force, these people had jitters in their belly. What was it? These Gaud Saraswat Brahmins said that only people of our community could enter this particular temple. We alone could worship this particular temple. We alone could even perform all the rituals. But now with this Temple Entry Authorization Act, they are throwing open every individual to come and perform and worship this particular temple. So therefore this is completely incorrect. So what they did not file any petition. All the trustees sent a memo to government saying that look, all this particular act is applicable to public temples, but we are a private temple. But because we are a private temple, this act is not applicable to us at all. Kindly leave us and don't enforce this particular law on us. As soon as this memo was received, government order was issued in 1948 saying that this particular temple is open to all Hindus. Anybody who is a Hindu can get into the temple and perform and even worship. So therefore a suit was filed saying that this particular government order is wrong, and it was contested by the government. And during the pendency of this particular suit, the Constitution of India came to be formed. And therefore, suddenly, which was only a legal issue to be fought in the court, gained constitutional importance, and they said we have right under the Constitution, which is now recognized under the Article 25 and 26 as right to religion. And the order was passed, it went up to appeal, so on and so forth, ultimately reached the Supreme Court. So the court framed three major questions in this case. They said firstly whether it is a denomination temple. that is religious denominational temple or not. Secondly, if it is a denominational temple, are these people, Gaud Saraswat Brahmins or trustees who are there of this temple, are they entitled to exclude others, that is other than Gaud Saraswat Brahmins, from entering this particular temple to worship, and whether they are connected with their right under Article 26B at all. Then the third one, under Section 3 of the Act, they said, is it protected under Section Article 25(2)(b), and whether it prevails over 26D. Now, it was an interesting concept. One article of the Constitution says, under Article 25(2), that any temple of a public character, the state can throw it open to all Hindus. Why was it formed? Because we had the concept of untouchability, and in Article 17 we also see that abolition of untouchability is also provided under the Constitution. So they said so and so person of so and so caste can't enter a temple, so on and so forth. So they said the Constitution itself provides that people of all religion, of any faith in, but so as they are all Hindus, the public temples or a character of public temple should be thrown open to all Hindus. But whether that Article 26D, where it provides that a particular community, religious denomination, when they are doing, they can manage their own religious affairs, including the right of entry, so on and so forth. They have that right there also, but here they are saying it can be thrown open. So in this conflicting interests under Article 26 and 25, what should be the law on the point was discussed by the Supreme Court. And finally they held that in the pleadings by both the parties, the plaintiffs, that is the temple, had admitted the temple was a public one, but they only contended that it was a denomination temple, and the court said that it is a denominational temple. Gaud Saraswat Brahmins is a religious denomination, so therefore the temple is that of a religious denomination. But the character of the temple is not a private one, it is a public character temple. So therefore they said, then are they entitled to exclude other communities, stating it is a matter of their religion under Article 26B. Then they invoke the essential religious practice that was enshrined under the, or expounded under the Shirur Mutt case, and they say that it was never an essential practice of Hindus to exclude persons of different communities to enter a temple managed by one community. They rely on several chapters of Dr. P.V. Karne in this regard. They say that it never has the Hindu temple been secluded to only one particular community, so therefore it should be open to all. Then they say the right conferred under Article 26B to such religious denomination is subject to the law protected under Article 25(2), that is, any Hindu temple should always be left open for public, anybody can come and go, unless it was a private temple, it is of a public character, everybody should come. So they said these particular sections of Hindus who are also there, because it was a public character, everybody could come, and therefore not only in that particular case of Venkatraman Devaru, they said all denominational temples in India of public character, wherever it is there, they are always open to all Hindus, and the declaration was passed. Then we see in 1972 another judgment of Sheshammal versus State of Tamil Nadu and others. This was 1972 volume 2 SAC 11. What happened in this particular case was, there were several archakas of ancient temples of Tamil Nadu. They had challenged the constitutional validity of the Tamil Nadu Religious and Charitable Endowments Act of 1959, as that particular legislation related to appointment of archakas, position of hereditary archakas, disciplinary action to be taken against archakas, etc. The principal act was enacted in 1959. The amendment was brought to that act in 1970. Now what did this amendment do? Under the old act, they said archakas could be appointed by the board of trustees, or if there is a hereditary system, that hereditary archakas could also be appointed, because most of the archakas in India have always been hereditary archakas, so they go on the hereditary basis. This amendment act in 1970, they said they did away with hereditary archakas. They said whenever a archaka had to be appointed, they prescribed certain qualification for the archaka. He should know so and so agama, he should know so and so shastra, he should have a proper degree in the agama or the shastra, he should show certificate, and only based on that particular qualification could he be appointed as an archaka. Now the trust or the board of trustees always had the right to appoint the archaka. After a particular Archaka goes, the board would see the qualification of the next Archaka and they would appoint. But in case of hereditary Archakas, it would go on in a hereditary business. The 1970 amendment said that no more hereditary Archakas. Do away with hereditary Archaka. Even if a son wants to apply, he is only a son, he will also apply to that particular post. You look into his own qualification. If he is qualified, you can appoint, or you can go with somebody else also. So the concept of hereditary Archaka completely was taken away. Then the trustees of that all the temples were given more power to appoint anyone as either Archaka or various other servants of the temple. Then the power also continued with the trustees to remove any Archaka. It is not that once appointed he would be the Archaka for lifetime, but he could be removed if in case he mismanages, if he does not perform well, or if there is any complaint received by anybody on so and so grounds, or even on breach of trust. For all these grounds, a Archaka could be taken off from that particular post and somebody else could be appointed. Then, as I already told, qualifications of Archakas were also prescribed through separate rules. Then all these Archakas put together, they filed one writ petition and they said that under the Shaivite and Vaishnavites, our own tradition, hereditary succession is an essential and integral part of our religion. Wherever Archakas were there in hereditary only, we have been continued from time immemorial. Suddenly a law cannot come and say that no, this won't be taken away, because the essential part of our own religion is what they argued. And they said that therefore this particular act is unconstitutional. And they said that the object of the very act was to override the exclusive right of denomination to manage their own affairs in matters of religion by appointing Archakas. They said appointment right given to a trustee is there. More power was given under this act to a trustee, because the trustee could appoint anybody as Archaka, he could manage so on and so forth. They argued rightly, who is this trustee? Trustee is also a person who is completely under the control of government under the act. The trustees are not people whom we appoint. Trustees are also appointed by you. You nominate the trustee. So you are not directly controlling, but you are indirectly controlling through a trustee. So ultimately government is going to have a say on who should be the Archaka, how should he be there, should he be taken off, and so on and so forth. Then in this particular case, kindly see what for Sheshamal and for the entire group of Archakas, Nani Palkiwala was arguing, and this is what is recorded. Mr. Palkiwala on behalf of the petitioners argued that the appointment of a person to a religious office in accordance with the hereditary principle is itself a religious usage and amounted to vital religious practice, and hence it falls within the powers under Article 25-26. In his submission, priests who are all performing religious ceremonies may be chosen by a temple on such basis as the temple chooses to adopt. How a Archaka should be appointed was left to the temple. It may be by election, selection, competition, nomination, or hereditary succession. He therefore contended that any law which interferes with the aforesaid basis of appointment would violate religious freedom guaranteed under Article 25 and 26. In his submission, the right to select a priest has an immediate bearing on the religious practice and the right of a denomination to manage its own affairs in matters of religion. Then he argues that the priest is more important than the ritual, and nothing could be more vital than choosing the priest. Under the pretext of social reform, he contended that the state cannot reform a religion out of existence, and if any denomination has accepted the hereditary principle for choosing its priest, that would be a religious practice vital to the religious faith and cannot be changed on the ground that it leads to social reform. So you cannot try to bring social reform by way of changing priests, that, etc. It has to continue. And how a particular ritual will be held is mostly at the hands of a priest, because it is the priest who does the daily puja. If you keep on changing him, the daily puja would also suffer, is what he argued. Then after hearing the arguments, the court goes against him and holds that the Archaka is not a spiritual head of any institution. Archakas are often chosen by the Dharmakarta or the Shabahit. Therefore, Archaka is only a servant of the temple. Even hereditary Archakas are also servants of the temple. Once he is a servant, there is a master. So therefore, the trustees who are now taking the place or who stand in the shoes of those the Shabahit or the Dharmakarta who were there, they can also take disciplinary action, and disciplinary actions must follow, and accordingly so also his right of appointment and qualification. And the position and appointment of Archaka to a temple is therefore a secular activity and not a religious one. So they said, under the constitution, there was a cleavage given, saying that if whatever secular activities are connected to a religion, that is saved. The state can do any secular activity. They said, appointing of a particular staff to take care of something. So they denigrated the Archaka to a level of some servant or a staff, and they said, you may be appointing somebody to clean You may be appointing somebody to take money and give receipts. So also you are appointing somebody to do archakas. They again rely on the history of Dharmashastra of Kane, and they go on to say that archakas were earlier, Kane himself records that archakas were appointed by Shavahis, Dharmakartas, etc. So we have seen the concept of appointment. So the moment there is an appointment, it is just like our service law matters where government appoints somebody as an official, the same way he is appointed as an official. Regular service law rules similarly has been followed here, so there is nothing wrong in it. Now in 1965 also a similar case of Chidambareshwara Temple versus Commissioner, Hindu Religious Charitable Endowments, Madras was also fought. In 1965, volume 78, Law Weekly 404, Madras High Court passes a judgment in which they say Chidambaram is a public temple, and these members of this Nathukottai Chettiar community, they cannot claim exclusive right of worship this particular temple. Anybody can come, anybody can worship. So they cannot say that we will only hold the archakaship and continue. This was also one of the judgments that was passed by the Madras High Court following the other Supreme Court judgments. Then we come to 1997 and we see that Adi Vishweshwara, in the case of Sri Adi Vishweshwara of Kashi Vishwanath Temple, Varanasi was a state of Uttar Pradesh. 1997, volume 4, SCC 60. The provisions of the UP Sri Kashi Vishwanatha Temple Act 1983 was challenged. Sections 4 to 6 and 16 to 22. Now, what did this act do? This act said that the management of the Kashi Vishwanath Temple was in the hands of the Pandas. They said the entire management which is in the hands of the Pandas had to be taken away and it has to be given to a board which is constituted by the government. It is called as the Kashi Vishwanatha Board, Kashi Vishwanatha Temple Board. That particular board would be given the entire right of management of this particular temple fully. And this was argued by the Panda saying that look, it affects our right to religion, it affects our right to livelihood also, because we were completely dependent on that particular temple and the entire community was taking, and you cannot completely take away our right and put it to a government appointed board. Then after contest, the Supreme Court finally holds, and they also had said that the UP government cannot make a law like this on taking away administration, giving it to the hands of somebody, because they do not have the legislative competence to do so. It should be directly with the central government. UP government also cannot do. So the first question was that of whether the state government had the authority to enact a law. Supreme Court very clearly holds, and rightfully so, that the legislature is competent to enact the law. And they say why? The reason given is somewhat disturbing, because they say the management and administration of a secular is a secular function. Management and administration of any institution is a secular institution, and so also this temple called Kashi Vishwanath Temple. So this secular function, if there is a law being made, you cannot go and say that the government did not have the legislative competence. They had the competence. Then second, they say this particular temple called Kashi Vishwanath Temple does not belong to any particular denomination. They say the believers of Shaiva form, the Shaiva form of worship do not belong to any denomination or sect. Who worships Kashi Vishwanatha? Literally everybody in India who are all Hindus worship the Kashi Vishwanatha. Can you say that all of them belong to one particular religious denomination? No. So the worshippers of the Varanasi Vishwanatha Temple cannot be called as a particular denomination at all. Now when you call the worshippers as not belonging to a particular denomination, how can you say that the temple is a denominational temple? Therefore, temple is not a denominational temple. Therefore, the Shaivites also cannot claim their exclusive right to worship and manage temples, including the right to receive offerings given by the pilgrims to Lord Shiva, to perform puja and religious rituals which are handed down through several centuries. They argued saying that these we people, our family, our ancestors from time immemorial have been doing this particular puja and we have been collecting and we have been managing. What has happened to the temple administration? Nothing has happened. It has continued. And devotees throng, they come and they go. So how can you come and say you are altering something which has been in usage for several centuries? So they said all of this you cannot claim it as a matter of exclusive right. Government of course has a hand. So if government wants to make a law in which they can take your right and give it to a particular board in order to manage effectively, it can do so. And they held. And they said, the Pandas had also argued saying, even if you make a law, we should have recognized, the government should have recognized that we people have been offering. So a law should have also been framed within that legislation or the statute to give us certain special rights as Pandas. So they said the absence of the provision to appoint pandas on board is also not violative of Article 25-26. So that there is no compulsion for people who were managing the administration earlier to be on the board of the government. So the government may choose that if you are managing a temple, you can be on the board, but the government can also say, sorry, I don't want you, I will put somebody else. All that the government was required to do was that they should ensure that a Hindu is managing and nobody else. Then subsequently, we see the case of Subramanya Swami was a state of Tamil Nadu, which again relates to the Chidambaram temple. A brief history is required to this particular case because it is not something that happened in 2014, because many people mistook the legal principles evolved in 2014 to say how Chidambaram alone could get management while other temple, why could they not get management? How is it different? Now, in 1952 only, there was a case called as Marimuthu Dikshitar versus State of Madras, 1952, Volume 1, Madras Law Journal, 557. See, this Sabayanayagam temple at Chidambaram was administered by Podu Dikshitars. Now, as per a scheme that was framed under the Madras Hindu Religious Charitable Endowment Act, an executive officer was appointed at that particular point of time. The Dikshitars challenged the appointment before the Madras High Court. They said that how could you make a particular law and also issue a government order in which you would say that an executive officer would come and do this. We Podu Dikshitars have been managing, it is our right. Then the appointment of this executive officer was challenged in the Madras High Court as a writ petition. Challenged by invoking the provisions of Article 25-26, they said it is our right to religion, and it very clearly says our own denomination we could also administer. So, if the right of administration is there. The Madras High Court held in favor of the Dikshitars way back in 1952, and they said that you have a constitutional right, it can't be taken away by the government. So, therefore, you have the right to continue and administer the religious affair, and they finalized it. After that, at that particular point of time, the High Court held three main things. One, they said the Dikshitars, being Smartha Brahmins, they form a religious denomination. Second, they said these Dikshitars are entitled to participate in the administration of temple. Then they said it was also their exclusive privilege which was followed for centuries. This was held in 1952. Then, challenging this verdict of the Madras High Court, the Commissioner of the Charitable Endowments preferred an appeal before the Supreme Court in 1952. But when the appeal was pending in the Supreme Court, as fate would have it, the government, because of the popular political opinion or so forth, withdrew the notification, which was challenged before the High Court by Dikshitars. They withdrew that notification and they said, this order appointing executive authority we have withdrawn. By virtue of that withdrawal, they came and said this matter has become infructuous before the Supreme Court. Nothing else lies because what is under challenge itself has gone. So, what are they fighting? It was become infructuous. So, Supreme Court did not render a judgment in that case. So, they had become final. So, all this happened in 1952-53. Then in 1987, the Commissioner was exercising powers under a new act called as the Hindu Religious Charitable Endowments Act of 1959, which was much after all these cases had over. Then exercising powers under 1987 Act, he said, I am appointing another executive officer for administration, and they tried to take over administration of the Chidambaram temple. The Dikshitars once again filed a writ petition saying that no, how can you again appoint one more authority? They said earlier itself this matter has been over. The government took a stand saying, sorry, that was under the old law, this is under the new law. I can still come and take away your administration, and they challenged it. The Madras High Court, by then, this was subsequently, much after 2000 or so. So the Madras High Court by then had already all this Kashi Vishwanath Temple, Sheshammal case and Shirur Mat case, all of this law had already evolved. So they said you are not belonging to any religious denomination, nothing, you don't have any right. So therefore I am going to reject your petition, and they rejected this petition. So these Dikshitars filed a writ appeal. From single bench it went to division bench of Madras High Court, and when the matter was pending before the division bench of that court, Subramaniam Swami filed one impleading application. He said, I also want to argue in this case because I am also a devotee of Chidambaram, and he filed one impleading application. That impleading application was allowed by the division bench, and he was also permitted to argue as one of the impleading applicants. He argued, but the main contesting parties there were Dikshitars. They argued. The writ appeal also was dismissed They said that no, you don't have a right, government can come and take over. Challenging this, Subramanian Swamy preferred an appeal before the Supreme Court, as he was one of the parties. The implementing application was allowed. This is how the case came to be known as Subramanian Swamy was a state of Tamil Nadu. It was not litigation initiated by Subramanian Swamy, he was only an implementing applicant. Main case was contested by Dikshitars. So when Subramanian Swamy preferred an appeal, the matter was pending before the Supreme Court. The argument there was completely different, and they argued very nicely, saying that look, whatever it is, legal, illegal, whatever, this entire issue of a particular government appointing a particular executive authority to take over the administration was settled in respect of the same two parties, that is Chidambaram Temple, Dikshitars, as well as the state of Madras way back in 1952. In law, we have a legal principle called res judicata. That means that between the same parties, if a case has already been fought and if it has attained a finality, the parties cannot come and file one more case alleging the same thing on the same cause of action on the ground that no, the law has changed, something else, now I have a right. So this is applicable everywhere. Same two parties, now law would have changed. You cannot come back and say, I want a particular right. Daughters did not have a right under Hindu law, now they have a right. They say, oh sorry, earlier judgment was dismissed against me because I did not have a right. Now Hindu Succession Act has given me a right. Now I want to file one more case in which I want to get right. Court will say, go out. You don't have any right, because by principle of res judicata, between same two parties, if a judgment has already come into picture and it is finalized, you cannot reopen it again. So this was argued before the Supreme Court, and they said this had already attained finality. So the Supreme Court said, however, the law, the manner in which it existed in 1952 before Shirur Mutt case and now has completely evolved and it has changed. But nevertheless, they said, although the law would have changed either by way of precedents or by virtue of any constitutional amendment, even a wrong judgment is a judgment because it has attained finality. And because it has attained finality, we are handcuffed not to reopen the legal issues in this case or religious issues, the right of person under Article 26 vis-a-vis the rights of the state. So therefore, by virtue of the judgment given in 1952 and state not challenging it, they withdrawing it and making it infructuous, that stands. So therefore, administration will continue to go with the Dikshitars of the Chidambaram Temple. It was only in this manner that they had a narrow escape, and Chidambaram was continued to be under the hands of the Dikshitars administration. Then afterwards, we see the major judgment, that is the Shabrimala judgment. Indian Young Lawyers Association versus State of Kerala, 2019, Volume 11, SEC 1. This was, most of these judgments that I have told so far was all constitutional bench judgments. So whenever a matter of constitutional importance is being argued in the Supreme Court, the law is that at least 5 judges should sit to decide that particular case. Here also, in Indian Young Lawyers Association of the State of Kerala, the Shabrimala case, 5 judges were appointed. We all know about the Shabrimala Temple, and most of you already know the facts of this particular case because it is in recent public memory. And basically, there were a particular law or the rules that was already made by the Kerala Hindu places of worship rules, in which they had recognized the custom in the Shabrimala temple, in which menstruating women could not go and visit that particular place of worship. They said all women between the age of 10 to 50, they could not enter that particular premises and they could not visit Swami Ayyappa. You can only go before you are 10 or after you are 50, more so to do with your age of menstruation, because Swami Ayyappa is a bachelor and we should respect the particular ideals that was there within the Hindu custom at that particular point of time. So, the matter was initially before a 3-judge bench, and because certain constitutional rights had arisen, it had gone before the constitutional bench. Now, what had happened? There were some of these women who had formed an association called as Indian Young Lawyers Association, and these women said that this was a very age-old practice. Now, the Article 25-26 does not make a distinction on the manner in which one would have the right to go to temple and worship. I am a woman. I am during the menstruating age only. I am aged about 30, 20, 40, whatever it is. I still want to go and see Swami Ayyappa. How can you stop me? Is it not against law? Is it not against constitution? the constitution very clearly says that the state shall not do any acts by virtue of which discrimination can be made on grounds of race, sex, religion, so on and so forth. So here is a clear discrimination on the ground of sex. You are saying that women alone can't go, women also a particular age cannot go, and majority of the women are in this particular age of 10 to 50. So therefore it is a clear discrimination on the ground of sex, and therefore it should be nullified. And this particular Kerala Hindu places of worship rules, which make specific provision in respect of Shabrimala Temple and says that women of this age should not go, is unconstitutional, and they challenged this particular act and also the customs there. Interesting arguments was being made. What happens whenever you file a writ? This was in the nature of PIL. There is a public interest litigation which was directly filed. Whom did they file it against? They filed it against the state of Kerala, and they also filed against the Travancore Devaswam board, which was managing the affairs and administration of the Shabrimala Temple. Now this Travancore Devaswam board is also a board which is formulated by the government. They take into account some of the priests who are there, so on and so forth, and they have formed a particular board for administration. So they argued in this particular case, saying that how can a writ petition lie, firstly? Because whenever we go and file a public interest litigation or a writ petition, it can only be against a particular state. Who should not discriminate? The state should not discriminate. If an individual discriminates on the ground of sex, that is not illegal, that is not unconstitutional. Constitution only states state should not discriminate between men and women or on people of other religion. They said, how can Shabrimala Temple be called as a state? There is nothing concerning here to say that Shabrimala Temple can be a state. So how can you maintain a writ petition against Shabrimala Temple? If the government is doing something, go complain against the government, you can get a writ issued of mandamus. But when the Shabrimala Temple is there, this is not state or other authority as defined under Article 12. Accordingly, none of the fundamental rights can be enforced against a temple. The way you can go approach, see, in all the earlier cases that I just now discussed, who was fighting against whom? The temple administration was fighting against the government. Now the government was making a law. The temple administration said, I am going to fight this because this law is affecting my right to religion. Here is a person, whereas a devotee is coming against the temple and saying this temple is violating my fundamental right. So they said fundamental right can be violated by any non-government entity and you don't have a constitutional right for it. You only have a legal right for it. But you cannot go and complain in a constitutional court and say that the non-state authority, if in case it violates, I still can issue a writ against them. They said courts are handcuffed to issue a writ against the Devaswamam board at all. They said, no, it is receiving certain state funds. They were able to also establish and show that what is state giving to us, we are giving to state more than what they are giving it to us, because most of the devotees who come and pay is all in the state board, in the Devaswamam board. That is taken by the government and they are giving. They also raised a very important argument here saying, for somebody else, for a private entity also to be called as a authority under Article 12, we should have received some money from the Consolidated Fund of India. Not a single rupee has been received by the Devaswamam board from the Consolidated Fund of India. So how can writ petition lie? So on the very ground of maintainability, major arguments were there, plus also on merits, what is the competing rights of a particular temple as against the rights of individual worshipper versus the temple. All of these were also argued. Then when the reference was made to the constitutional bench framed 5 major questions. First they said whether the exclusionary practice which is based upon a biological factor exclusive to the female gender amounts to discrimination and thereby violates the very core of Article 14, 15 and 17 and not protected by morality as used under Article 25, 26. I yesterday read out Article 25. They said, subject to public order, morality, health, you have a particular right. They said, so therefore, whatever right you are exercising is subject to morality. Does it not come under morality? Was the first question. Number 2, whether the practice of excluding such women constitute essential religious practice, and Article 25, and whether a religious institution can assert a claim in that regard under the umbrella of right to manage its own affairs in the matters of religion. Third, whether Ayyappa temple has a denominational character, and if so, is it permissible on part of the religious denomination managed by a statutory board and financed under Article 290A of the Constitution of India out of the consolidated fund of Kerala and Tamil Nadu to indulge in such practices violating constitutional principles or morality embedded in Article 14, 15, 39 and 51. Fourth, whether Rule 3 of Kerala Hindu Places Worship Rules permits religious denomination to ban entry of women between the age of 10 to 50, and if so, would it not play foul of Article 14, 15, 3 by restricting entry of women on this ground of sex? Number 5, whether the same Rule 3b of Hindu religious worship rules is ultra vires the Act. If in case it is not ultra vires the Act, is it ultra vires the Constitution? So the very framing of the question was in particular manner in which the judgment would also know as to how it would come. Finally, the Supreme Court held that Shabrimala is a public temple, it is not a private temple. The moment that public temple came, the earlier judgment they said it is of public character, all these articles would apply. Second, they said all powers vest with the Devasthanam board. The moment you are called as a public temple, the Supreme Court says you become an authority under Article 12 of the Constitution, and therefore anybody can file a writ against you. This was a idea which was not existing in any of our laws until the formation of this judgment in Shabrimala. So today, if in case this judgment were to hold ground, anybody who is aggrieved by any particular temple can go and say this temple is violating my right, and the way you can complain against the government, you can go against the temple also. Then third, they said once it is held as an authority or state, which they held, and as it is receiving aid under the rules after the insertion of Article 290A, no individual ill practice could go on in any temple associated with the board. Then they said temple is a public place, and therefore right of entry and right of worship is a fundamental right provided to all. You cannot differentiate on the grounds of religion, sex. Then they said for such right to be affirmed, that is right of a woman to go, right of a man to go, individual right when it has to be affirmed, you cannot come back and say there is certain custom or immemorial usage, so on and so forth. Even if you are able to prove that some custom usages exist, individual freedom will take precedence over this, and they will be able to go and assert their right. And finally, they said this particular action falls within the term morality under Article 25. So therefore, all the rights of this particular temple to have their own religious affairs is subject to the morality. And the constitutional morality was an old principle. Under some other heading it was evolved. They used that particular principle here, and they said subject to morality, therefore your right exists, and therefore the temple cannot claim their fundamental right competing with the individual's fundamental right to come and say. However, there was a dissenting opinion, 4:1, and the 4 male judges wrote in favor of the women, and the 1 woman judge dissented in favor of men. And Justice Indu Malhotra first says the Travancore board doesn't receive any funds from consolidated funds of India, therefore it is not an authority or a state under Article 12. Then they go on to say that even Article 290A, which they are all relying on to say that it is a character of public institution, etc., it does not take away the denominational character of any religious institution. And then they say I don't see any fundamental right being infringed, and these custom and usages will have to be given effect to, and when competing fundamental rights are there, how it has to be looked into. She gave a completely different opinion, and she said that the petition will have to be dismissed. However, on majority it was held. However, now this again, one more question has again been referred. A review petition was filed. By then certain judges had retired. It came up before another bench, and by majority they have referred this question to a larger bench, and this entire issue, the way in which it has been evolved, is being argued before the Supreme Court. We will see what happens. Then there are a few other judgments that we will have to look into, is mainly this Ayodhya case, M. Siddiq versus Mahan Suresh Das, 2021 volume SEC 1. In this particular case, it is very important to see the very first sentence of this particular judgment. They make it like a book, and in that judgment, they also have an editorial note also, in which they say, despite the enormous importance that a large number of people of both communities, Hindus and Muslims, placed on the disputed site of Ram Janmabhoomi, due to their belief and faith, this case was decided on the basic settled principle of property law alone. Usually, when anyone seeks to establish title to any piece of land, the first recourse is to documents of title, either from a sovereign state or a previous owner. Neither party could establish this. The Muslims first claim to the title of this particular property that it was through Emperor Babur, and he had made a specific grant of the disputed site to them. However, there is no documentary evidence existing in this regard, and they had to recourse to 3 other alternative ways of proving title. One was doctrine of lost grant. as they still maintained that there was a grant from Babur, but they have lost it. Number 2, on failure to establish that particular claim as per law, the next claim was by waqf by user, which again could not be established on facts. And lastly, they claimed it on the law of adverse possession. That is, to the knowledge of the true owner, if a particular person like a trespasser comes and sits on the property and that fellow does not take any action for a length of time, by law of adverse possession, I become the owner. So that is the 3, and they are saying we are in adverse possession from 1528, which again was rejected due to insufficient pleadings and proof. The Hindu party sought to establish title to the disputed site in 3 principal ways. First, that the title continued from 12th century BCE, 12th century Hindu temple excavated at the disputed site by ASI. Number 2, existence and continuation of which title they could not establish. Land itself was a deity which amounted to claim of absolute title, which was resoundingly rejected by a number of grounds, and they were in possession of the disputed site from time immemorial. Then ultimately court had to go on evidence, and despite several documentary evidence made available to the court from the Archaeological Survey of India and the right of contesting religious parties, and also their parties holding that how much sanctity this particular place holds to both this particular faith, etc. The court goes on the question of property law and of adverse possession, and they say that Hindus at no point of time had stopped worshipping this particular place, and they are able to show that they were accessing this particular place and are also worshipping much, at least 100 years, if not 240 years that they claim before 1857, because suit documents were available in this case from 1857, and several things had happened in this particular case by virtue of which suits and several orders being passed were all part of the record. So ultimately they held, before they were holding it when this case was still pending, in 1991 a law was enacted called as the Places of Worship Special Provisions Act. In this, the provision said that no religious place could ever be converted after August 1947. So whichever religious place is holding as of August 1947, if it is a mosque, it will continue to be a mosque. If it is a temple, it will continue to be a temple. If it is a church, continue to be so. And nothing could be changed. However, they very clearly said this act will not apply to Ram Janmabhoomi. This leeway was granted by the central government in 19. Why did they do so? They were not favoring Hindus or Muslims. They did so because several suits were pending and it was being litigated in the court. They were aware of that litigation. So they did. Then we all know in December 1992, the demolition of Babri Masjid also happens. And then in 93, the central government under P.V. Narasimharaja Rao enacted a law called as Acquisition of Certain Area at Ayodhya Act of 1993. By virtue of this legislation, the central government said, I have right of acquisition. This right of land acquisition by the government was confirmed by Supreme Court long back, and they had several laws. And there is no prohibition for the government to take only private properties and not temple property. They have right of acquisition. So P.V. Narasimharaja Rao said, all right, I will go and acquire this entire land of disputed site, and I leave it to me. I will allot it to whomever I want. So he passed this particular law and he said this entire land would be acquired by me for some purpose, public purpose, under the land acquisition. They formed a separate act and they acquired. And during the pendency, this act was also challenged as unconstitutional, and ultimately in 1998 one judgment came, subsequently 2002, and they said this particular act is unconstitutional because they wanted to acquire entire 67.7 acres. And then finally we know the recent judgment of the Supreme Court in 2020 when they said that Muslims have been able to claim adverse possession for so and so part of area, and Hindus are able to show the entire title for major portion of the area. But nevertheless, in matters of faith and so on and so forth, the entire disputed area would be given to Hindus. As an alternative, the government will have to give some other area for establishing of a mosque and should also support them in somewhere nearby within a radius of so and so kilometers. Was the judgment passed. Because of the religious character of the dispute, I had to say this, but from a perfect legal point of view, this was not considered to be a judgment on religious fight at all, or articles of right to religion was not invoked to give this particular judgment. If these were all some of the judgments that was passed in respect of Hindus, let us see some of the laws that were made and the judgments that were passed in respect of Muslims. The Muslims had, as I told you, in 1923 itself, the Musalman Waqf Act. Now the way many of the temples and charitable institutions had their own lands, similarly Muslims in and around mosque, etc., whatever land was given to either the mosque or the imam of that particular mosque, they would also have a particular property. It was governed under the Musalman Waqf Act. What does it say? It says that it has to be administered as per the injunctions of the Quran, but it has to be administered properly. There should be no mismanagement. And whatever are the injunctions in the Quran for your performance of your daily religious activities within a particular mosque or any activity connected with that particular mosque would have to be given effect to. So basically the law is saying whatever Quran says, you continue to do that in respect of all these properties, but there shall be a particular controller from the government end, you shall report to him. The Maharashtra and Gujarat state governments have made certain amendments to this Waqf Act. Only these two states under the amendments have brought in lengthy legislations under the Waqf Act, almost supervising some of the Waqf properties under these two states, as though the government in all other states are making some administrative control over the Hindu temples. So barring these two states, nowhere in India do we find that Muslim institutions or the Waqf institutions are having any sort of supervisory or administrative control or control on the finances or on these economic activities at all. Now, the constitution did not say, ask the state to frame laws to administer temple or property, temple or mosque or church. They said the state may make a law on this. May does not mean you shall do it. The government always had the option not to frame a law. The manner in which they have framed a law for the Waqf, nothing stopped the government to frame a similar law in Hindu temples also and said, you will be guided by the text of Dharma Shastra in managing and administering your temple, and you should ensure that you are doing it in a fair manner. And if there is any issue between the manner in which it is evolved so and so, there will be a separate board which will be constituted as a judicial authority for which you shall go and complain. No appeal will lie from there. All these kind of laws could have been made, however they have not done it. In respect of this they made. Then there was another Qazi's Act of 1880 which the Britishers had made. Even under the Qazi's Act they said the Qazi had the authority. What all authorities are there? Whatever is there in Quran, that particular Qazi would have that particular authority. And to the extent of authority given, if there is any religious issue, if there is any issue between two people, either subject to their marriage or any other private affair, Qazi would be the last man to give authority, and the law recognizes what the Quran says about the rights of a Qazi under the Qazi Act of 1880. Then there was Kuchi Memons Act of 1938. The Kuchi Memons Act, they said, okay, because you want to be governed under the Muslim law, so on and so forth, that act is also, the Shariat Act is also applicable to you. So most of these acts all came with less than 2 pages. Most of these laws came into picture. Anyway, we will see some of the other judicial pronouncements that were passed. In Sardar Syedna Tahir Saifuddin Sahib versus State of Bombay, which was a constitutional bench judgment, AR 1962, SC 853, there is a community in Muslims called as the Dawoodi Bohra community. They say that we belong to the Shia sect, and they said that they believe that Ali, the original next in line to Prophet Muhammad who was there, who had a very, very short tenure, and thereafter Aisha's father takes over. Anyway, that is a different story. So the successors of Ali always had appointed one or the other persons, and with these imam, they had appointed somebody called as the Dais. And this Dai ul Multak, who would be appointed under the Shia, the religious practices of Shia, he would have the right to govern that entire community. And what happened? There was an act in 1949 called as the Bombay Prevention of Excommunication Act. They said you cannot excommunicate any person from a particular community or from a particular society the way you want. And it was a normal excommunication prohibition law which was applicable to everybody. The moment this excommunication law was framed, this Daiul Multak, he goes to the court and say, I have a constitutional right under Article 25-26 to excommunicate my man. So this particular right is given to me by all my religious injunctions, and these religious injunctions very clearly say that if I want to boot out anybody, and that authority is given to me as Daiul Multak, that cannot be done away by a law like this. So who are you to interfere in my religious affairs? So I will continue to hold. So therefore he said, my right to excommunicate my own member as being the head of this particular religious denomination is my fundamental right under Article 25 and 26. The court says that sorry, this is pre-constitution, whatever was there is different. Under the constitutional regime, this is not possible, and they dismiss it. Then this is in respect of their right of worshippers, the manner in which they approached. Then we have another case of Durga Committee Ajmer versus Syed Hussain Ali and others, AR 1961 SC 1402. We all know about the Ajmer Dargah. There was an act, legislation framed called Durga Kwaja Sahib Act of 1955, and this particular act basically tried to have administrative control over the Ajmer Dargah. This is the same manner in which several other temples, etc., they tried to have. This was challenged before the Supreme Court in 1961, and they said this particular act is unconstitutional because we have certain rights. Apart from the regular religious rights they have under Article 25 to 28, they said we also have right to manage our own religious institution as a minority community also. And therefore, for preservation of our cultural community, so on and so forth, they said this had to be, the act of this Dargah Khwaja Sahib Act would have to be held as ultra virus. They first filed that petition before the High Court. High Court goes in favor of those people, and they say that this particular Dargah committee which has been formed under the legislation is unconstitutional. They have the right to manage their own, and you have no right to come and interfere or poke your nose in administration. And High Court gives an order in favor of the Muslims. This was challenged before the Supreme Court. Supreme Court dismisses that particular appeal, and they say that you can administer your own institution, we don't have a right, that is, the government does not have a right to interfere. So we see in Dargah Committee Ajmer case, in contradistinction with several other cases that I already informed, that how the Hindu religious institution, by virtue of a same legislation when they tried to control, when they go to the court, they have got a judgment in which they said the act is correct, but only some provisions may be wrong and you will continue to hold and administer. Here similarly a law was passed which has been held as unconstitutional, and they say that you have the right to administer your own. Then we have the famous Shah Banu Begum case, again right of a Muslim woman. What had happened? Shah Banu Begum was married. The husband gave her talaq, divorce. After the talaq was given, they have a concept under the Islamic law called as the meher. Now Hindu marriages are all called as sacraments, but a Muslim marriage is called as a contract. So under this contract, we have an offer, we have acceptance, and we have consideration. So similarly there they say, if in case I were to marry you, and if I don't take care of you and if I leave you, I have to pay you a certain amount. That consideration is called as a meher. Now what is that meher? They would say, if I don't manage you at all, I would give you X amount of rupees for not managing you, and that is called as meher. You take it and go. That is your maintenance. Generally, how much is this meher amount? Meher amount is generally around 3,000 to 5,000 rupees, sometimes 10,000. In very rich Muslims, meher amount can even go up to 50,000 rupees. This is towards full and final settlement of all the wife's dues, and which that amount is given, they would take and go and have to live with the rest of that life. So what had happened? The Shah Banu Begum, she was divorced by the husband, and he said, oh, here is your meher amount, and take at that point of time from 350, 400 rupees was there. He paid the 350 rupees with a magnanimous heart, and he said, this is your meher amount, I have paid you in full, you please take it and go. She said, what am I going to do with this? Now, she knew that if I go to the Qazi and if I ask for maintenance, he will say, he has gone by the rule book and he has given you the meher. How can you come back and say that I want more? He has given you fully. But how she had children and she had to manage. So what she did, there is a provision under the Criminal Procedure Code 1973 called Section 125, which says that if a particular maintenance has to be made by your family members and they don't maintain, you can file a petition under Section 125 for maintenance. Who could file? Any wife can file against the husband, parents can file against the son, children can file against the parents. Anybody who have a right to be managed or to be maintained, and if they are not maintaining, law gives a general provision for everybody to say, you please go and maintain. So she filed Section 125 petition, it's called as criminal miscellaneous petition. She filed it and she said, I want maintenance, whatever they are paying me as meher amount is peanuts, I can't live my life with this. So the argument obviously by the husband was that I am not governed under the general law, I have a special law. See, what is the legal principle? Whenever there is a general law and there is also a special law overrides the general law. Because even here we have Samanya Dharma, Vishesh Dharma, same way, special law always overrides the general law. So they said special law, my personal law should be there. You cannot come back and say that despite my special law, I will have to pay her maintenance, not possible. So she kept losing everywhere until she knocked on the doors of Supreme Court. And Supreme Court in 1986 made a judgment looking into the entire gamut of the litigation. They said this lady has been fighting without any money and this fellow cannot pay peanuts and say this is it. So they finally gave a judgment and they said you pay her monthly compensation of so and so, pay her in arrears full and pay this particular amount. The way a Hindu woman when she is divorced would be entitled to amount, same way she would also be entitled. So what if Muslims don't have under the Hadith or the Quran for application for maintenance? The law today under section 125 provides. So all Muslim women can go under section 125 file and the right of maintenance would come. So this opened floodgates. Wherever Muslim women were not being treated well and there was a divorce, so on and so forth, they could all go and file section 125. And in the penultimate paragraph of the judgment, the Supreme Court also writes that the letter and spirit under Article 44 of the Constitution pertaining to Uniform Civil Code has remained as a dead letter. And the government of India has not been doing anything in this regard. Look at this, we have two types of women in the country, one following Islam, another not following Islam. And why should the women following Islam not be given the same benefit as others? And it is only humane for them to be considered. So therefore, you please we strongly recommend that the government shall take steps for a proper uniform civil code. Under Article 44 is one of it is only a reference, it is a passing remark, it is not an obligatory part of the government, it is only a request made by Supreme Court by virtue of the judgment. Then Rajiv Gandhi was the Prime Minister at that point of time. They said that okay, the government wants us to frame a law. They framed a law called as the Muslim Women Protection of Rights on Divorce Act of 1986. And through this Act of 1986, they said Muslim women should be protected and any divorce that happens, they have to be given the meher amount. Whatever is the meher amount given, that would be sufficient for maintenance of this particular lady. So therefore, meher amount should be paid and this is how she has to be protected. So virtually this legislation was made to completely contradict what the Supreme Court had passed. So Shabano Begum was the sole beneficiary of the judgment because she was a party to that case and nobody could rely on it as a precedent in order to claim maintenance under section 125. Now all Muslim women are still governed under the Muslim Women Protection from Divorce Act of 1982. Then we see Shaira Banu versus Union of India 2017 9 SEC 1. This is the famous triple talaq judgment. We all know that the Muslims also had the practice of divorcing women on the ground of triple talaq. They can marry up to 4 wives and if the 5th one are to be married, you can divorce any of the first 4 and you can also marry the 5th one. And even the first one, while marrying the second one, you can first give divorce to her and then marry the second one. There are several forms of divorces which are available. One of the provisions there, what they were practicing was triple talaq. So the Shaira Banu was one of the lady who was divorced from the husband on the triple talaq. He said talaq, talaq, talaq and that woman got divorced. So she said that I cannot say that I am divorced. Now it's important by virtue of this, the act made after the Shabanu Begum case, that a Muslim woman is not divorced because if she gets divorced, all that she is entitled to is a meher amount. But at least if she is continuing to be a wife, she may claim some maintenance from the husband as part of it, and even the Islamic law says you have to take care of your wife. So therefore, they don't want to be divorced at all. Now, the triple talaq they gave, and by virtue of this triple talaq, she said that this very concept of triple talaq is unconstitutional, and she filed a petition before the Supreme Court. The Supreme Court, while examining this case, studies the very primary documents of Islamic religion, which is the Hadith and the Quran. And they say, nowhere do we see either in the Hadith or in the Quran where triple talaq is mentioned as one of the modes of talaq. It is only in the secondary sources of Islam that this concept appears to have been developed. Since it is not in the primary source at all, we cannot say that this is protected under the Islamic laws. So therefore, they say there is no constitutional basis for me to protect. Now, if you are not covered under the primary sources, you would have to come within the 4 corners of the constitution to see whether this triple talaq can be held as constitutional or not. Again, they go on the concept of religious right versus morality. They go on it and they say that sorry, this is completely immoral. to say a woman who has been married for a few months, weeks, or even days, or can be years, can be divorced just by saying 3 words, even in the heat or fit of rage, and that particular woman would lose all rights. This is not possible. And they hold and that triple talaq, the concept of very triple talaq, is ultra vires the constitution and therefore unconstitutional. Then we see the recent hijab case, which is still pending in the Supreme Court. In the High Court of Karnataka, you all might be aware that in the Government College of Udupi, few 2-3 girls started coming to school suddenly. They were wearing a particular hijab. They were asked to take out hijab. They refused and they said, it is my religious practice. The school authorities vis-a-vis the government put its foot down and said that no, if you want to study in a secular institution, that to a government aided institution, you would have to leave out, not wear this particular dress and go with the uniform. They said, along with the uniform, if you wear hijab, how is it going to affect you? So it is our religious right. And finally a government order was passed in which they said everybody irrespective of your religion would have to only go by the uniform. Sikhs are the only exception because that exception is carved out under the constitution itself, where they say wearing of kirpan, so on and so forth is a constitutional right for Sikhs, and that cannot form within the secular aspect, is a protection given under constitution, except that nobody else can wear anything else. So that was the government order passed. The government order was also challenged by way of several writ petitions in the Karnataka High Court. The Karnataka High Court, after hearing both the parties, ultimately came to the decision saying that wearing of a hijab is again not in the primary sources of Quran, primary sources of Islamic law, which is the Quran or the Hadith, and this particular dress code, many religions would also mention here, and there is no wrong for a particular person to wear that particular dress and go anywhere. But when you go to a school, they argued saying that it is a public place and I can wear whatever I want before a public place. So the respondents had argued saying that school may be a public place but is a qualified public place. So there is certain discipline to be maintained in a particular school, and if the discipline is one of the core aspects of the school, if discipline is not maintained, it is not a school at all. So therefore, in a qualified public place, certain regulations had to be in place. Court recognized that and they said, what are the rights in a qualified public place? And they said, the government order is valid, constitutional, and the full bench of the Karnataka High Court remarked and they said, this particular wearing of hijab only in so far as during their time that they spent in the school can't be worn, and the government order is constitutional. They have now preferred an appeal and the appeal is pending before the Supreme Court. The judgment is still awaited. Now, if these were a set of judgments, one would be wondering, from past 2-3 days, this man has been speaking on several Hindus and Muslims, several cases have been passed. What about Christians? Very well, there are no laws on churches. There have been no laws framed on administration of churches. Yesterday, I was saying that in 1857, after the first war of Indian independence, 1858, when the Queen's Proclamation was made, the first sentence that came out was that the British will not interfere into the religious affairs of Indians. After doing this, they realized, if by state power, if we try to go convert these people, if by state power, if we were to go and ask them to embrace Christianity or go to church, etc., it is not going to work out. What should we do? At that point of time, evangelical society took upon itself the responsibility to ensure that it would convert India into a Christian country. So, evangelical society thereafter formed several churches and several associations in India, and through the years, from past 150, 170 years that we have seen after 1857, several church associations have been formed and missionary activities have been going on. And it is an unfortunate factor that till date, there has been no law that has been passed which stops conversion, either forcefully or by luring by one or the other aspect. We have had several judgments on reservation, wherein we say, if a person is a minority enjoying, not a minority, if he is a SC/ST enjoying certain status, if in case he gets converted to Christianity, whether will he continue to have that SC/ST benefit also or not. These kind of judgments have been severally passed, and some have been given, some have not been given, so on and so forth. But now it is at the stage of a bill that has been pending in the Parliament. The bill has not yet been passed. There is a Central Act which still wants to make this law of forceful conversion or conversion by way of luring as a punishable offence, and also ask for reconversion. Now, our Hindu law also recognizes the reconversion. That is, if a person leaves this particular faith, goes out and again wants to come back, that aspect of reconversion is left open. But again, nowhere does it say that you should convert. All of these have not been provided anywhere at all. Then I would be failing in my duty if in case I don't mention about a particular law that was passed during the Indira Gandhi period, which was Land Laws or Agrarian Reforms Act. Now, prima facie, when you look at it at the surface, it does not pertain to religion at all, because it is only agrarian reforms, it is land laws. This is how the entire country views it. But in effect, if you were to see, a Hindu temple, at most part of it was not just a religious affair for us. For the people who are practicing Sanatana Dharma, apart from that being a concept of only a religious place, it was also the social center for that particular city or town. Several social activities used to take place, cultural activities used to take place, many meetings pertaining to the welfare of that particular city or town also used to take place, several dance and other performances used to take place, and so many people other than just the priest were also involved, very deeply connected with the entire functioning of that particular temple. It can be a person who is cleaning that particular temple, or it could have been the Devdasis, so on and so forth. Many people were connected and were dependent on the temple. And what did our text of Dharma Shastra say as a duty of the king? They said, unless until there was an emergency situation, you are not supposed to touch the funds of the temple. And in fact, you should go and protect. And all throughout our history, you would be seeing how so many kings would go and donate so much to the temple for the betterment. So many temples were given, the golden gopuras were installed, the deities were there, so on and so forth. So we would see contribution of the state. The king was the state at that point of time. He was the administrative head. So the state was actively contributing towards the welfare of the temple. And subsequently we see that the government is interested in taking the funds out of the temple. We have the Tirupati Tirumala Devasthanam Act, by virtue of which the government, the chief minister would be the chairperson of that particular trust. Other trustees would have to be appointed, and Archakas would also be appointed. They would have a share. They would have the say, in fact, to the entire amount collected by the Tirupati Hundi, and they would say how this particular. So how do we think Andhra government is so rich? Part of it owes to the Tirupati Tirumala Devasthanam itself. And most of the riches of this particular temples, which was only flowing one way earlier in the history, from the state to the temple, later on started going from temple to here. Then we see that a particular priest, when he was doing a particular puja in a particular temple, he would also be getting certain grants from the king. He would perform his particular ritual and also do puja for everybody connected with the temple. All the staff would all be given grant and remuneration directly from the king. Additionally, the kings also said that land would also have to be given to them. So that's why we have this Devdaya Inam and Inam given to Archakas, etc., which was part of the temple. So whoever was worshipping as an Archaka of the particular temple was also given a particular Inam land. And several persons connected with the administration were also given land. Not just temples, even mutts were given lot of Inam lands. So you have Dharmadaya Inam, you have Devadaya Inam. Even our own Mysore Maharaja had given so many Inams to these people. Now this particular Inam land was given, which made these people self-sufficient. They were not worrying about how much money you would put in the hundi or how much money you would put on the arti for them, for their livelihood. Their livelihood did not depend on the token amount which was given by the devotees to them. They were self-sufficient financially. Now what happens by virtue of these agrarian reforms? If a particular person were to perform the puja continuously in a temple, sufficient time would have to be spent by him in temple. There is the morning puja, afternoon, madhyanika, then in the evening also, starting from waking up the god until the Tottilu Seva or making the god sleep, he would be busy completely with the rituals in the temple. How would he take care of the agricultural producers to go and take care of the agricultural land, so on and so forth? So he would always keep certain persons as a laborers who would go and take care of the agricultural producers, give them a share, he would also take a share, and the family was okay, self-sustained. Then came the land of Inam abolition, where they said, like, tiller is the owner of the property. Same way they said, all these persons, whoever is even tilling even the Inam lands, automatically would hold all these particular Inam lands, and Archaka, even if he himself was tilling, he would have to go and file an application for occupancy rights, and they would be entitled for the lands. Now, virtually what this agrarian reforms did is, it drove 1/3 of the population into litigation. Now we see every land, agricultural land, in which either it is by virtue of a free holding land that was held where there was a certain tenant, or if it was a Inam land, or if it was some other Inam not being a religious Inam, any particular kind of land that was being held was all taken vested with the government, and they said, you prove that you are only tilling the land, only then you will be given back. As a virtue of which most of the Inam lands were completely lost, because the revenue records had always shown there were two columns. Even to this day, there are two columns in revenue record, column 9 and 12. 9 speaks about the owner of the property, 12 speaks about the person who is tilling that particular land. The revenue records had that column 12 only to say, because the tenant is daily managing the particular affairs on the crops grown, etc., any subsidy from the government, any crops that he wants, etc., that man can come and take. If his name is there in column 12, he would be entitled. So many tenants used to fill up. So they said that all those persons will get, and the Inamdar would lose the property unless and until his name existed in both column 9 and column 12. As a result of this, most of the temples and the Inam lands attached to the particular temples were also lost. So we see by a scheme and by policy that the government had snatched away day in and day out, not only during the British India, but even after independent India, and how the entire setup of temples and the mutts, etc., have only become poorer and poorer by day. And even to this day, whatever you are going to offer to the temple is in the hands of government. They can decide what they want to do with the money. There is still no injunction for them to say that whatever money you receive from this temple would have to be used only for the benefit of that temple alone. They do not say that the government cannot take any money out for performance of its own functions. Such type of this thing is not there. Only for minority institutions there are certain protections. Now these minority education institutions are also matters of religious affair. In the case of Ahmedabad St. Xavier's College versus State of Gujarat, AR 1974 SC 1389. In this particular case, what had happened was the education institution which was run by St. Xavier's College. As we know, Indira Gandhi was nationalizing everything. She was nationalizing petroleum first, then she nationalized transports, then she nationalized several other businesses. That way they also wanted to banks were also nationalized, privy purses was cancelled. Similarly, they wanted to nationalize even the education institution. So they said this particular education institution, which was St. Xavier's, this university also come into our fold, and government tried to take over. They tried to do with several universities. Nahipal Kiwala was the alumni of Ahmedabad St. Xavier's College, and he was approached by the alma mater. They said, you please fight our case in Supreme Court. He fought there. Now as a lawyer, what do? If in case you are fighting a particular case, whatever legal provisions are there which is going to help you, you would use all of it. So he said, right of any person to hold education or run education institution is a fundamental right guaranteed under Article 19. That apart, I also, because this is a minority institution which are Christians, we also have right under Article 29 and 30 here, because education institution right cannot be interfered with. So in 1974, the Supreme Court came back and said, yes, they are a religious minority, and when they are administering, the government cannot interfere with. And they passed a judgment, and they said that you can continue to hold despite receiving any public aid, so on and so forth. The government cannot come and say, I will take over, you will continue. But however, the judgment was later repeated in a series of judgments, and Unikrishnan was state of Karnataka was reversed. Then we see the state of Tamil Nadu in 93, and then we see Temepai Foundation case, Ismail Faruqi case, and finally ended up in P.I. Inamdar case of 2007. All of these judgments subsequently held that this right to be having your own say in running the education institution right solely with the minority institutions. Other than minority institutions, if you were to hold, then you would be completely subject to, or if you are a private institution, okay, but if you are taking any sort of aided colleges would all come completely within the purview of the particular legislations which would be made. So we see that in most of these cases, not many governments have even acted to ensure that there is equality in terms of the way government is treating several religion. it may not be, I cannot say that only one particular government is wrong. Every government from 1947 till date have not taken any positive steps to undo this. There has only been demands made to free temples out of everything, but has not been made. Several other legislations without their own knowledge is also affecting us. For example, the Archaeological Survey of India Act. Archaeological Survey of India Act mostly wants to protect archaeological monuments, and they don't make a distinction between what is a live temple and a non-live temple. So Archaeological Survey, they want to protect. So all these various protection methodologies that has been evolved by Archaeological Survey, and the powers that they get draw from under the ASI Act is one, but where live temples are going on, certain leeway had to be granted. One of the also law there is that within 300 meters, the ASI would have a stand on you can't do anything, you can't build anything, you can't reconstruct anything without their permission. First 100 meters, they can't do any construction. They can't even apply for reconstruction permission also. If in case any structure falls there, it falls. Now, please tell me how many, if you look at the number of archaeological sites and monuments in India which have been protected under the ASI Act, they will come and say that this particular is notified under the ASI Act, so now this is a protected monument under ASI. You visit several temples, you would have that ASI protected monument the notice being put there, board being put there. Now most of these, majority part of the ASI monuments are temples. Now who would stay within the 100 meters? It is the very priestly families, who are attending to the religious affairs of the temple are the ones who would be within that 100 meters. So if they want to renovate their house, they don't have permission. If their house falls, they don't have a right to reconstruct again. So according to ASI, you will have to go out and reconstruct. Where? You have to go out after 300 meters and reconstruct. Now the city would obviously would have grown for more than 300 meters. So you would go to the outskirts of city and then come here for worshipping. Then they also say many of the temples also have to run their own offices for your daily pujas and other things. So if some temple decides that I want to make an office for all the pilgrims or other devotees to come for issuance of receipt book, or for I want to construct a hall for feeding people free of cost or with money, they can't construct anything because it is within the area of 100 meters. So if they want to construct something, they have to go outside of 100 meters. Again, if it is already a constructed area, they will give permission to renovate. If there is a blank area, vacant area which the government or the temple is holding and they want to make a fresh construction, permission won't be granted to you. So without knowing, although ASI does not make distinction on ground of religion at all, it is affecting people. And politicians in matters of religions are entirely spineless. They completely rely on the judgments of the court. So when it comes to religion, they don't want to take any action because any political will would obviously be adverse to one or the other community. If you want to favor one community, the other community would cry foul. So therefore they don't want to take any action. Even in terms of Ayodhya, they wanted judgment to be passed by the Supreme Court, only then would they take some action. So in matters of religion, we have seen that there is a complete absence of political will. And this absence of political will has become an extra burden on the shoulders of the judiciary. And this particular judiciary, they had to be guided only by the laws made by the legislature. And these people do not even make laws properly in order to protect this religious institution. And we are therefore in a very, very sorry state. This entire lecture has more been in a types of complaint of a particular community. And one may say that he gave a very biased look. But any person with a very objective sense, if he looks into the entire gamut of laws and the judgments, I don't think can come to any other inference than what I have drawn here. I would like to thank Gokhale Institute of Public Affairs for granting me an opportunity to speak on this subject. And thank you all for listening to me with so much of patience. And I would also like to extend my thanks to my friend B.N. Shashikiran, to my mentor and friend, learned friend Shatabdhani R. Ganesh, for helping me in this entire lecture series. Thank you one and all.